Welcome back to a one-story teller, where stories come alive and truths unfold like never before. Today, we dive deep into a remarkable tale that challenges tradition, tests the limits of justice, and redefines courage. Imagine a royal guard standing proud at Buckingham Palace, fined, not for disobedience, but for wearing a simple cross. What happens when law meets faith, when duty clashes with conscience? Stay with me as we unravel how one man's quiet act of faith sparked a legal battle that shook the foundations of military discipline and human rights. This is more than a story about a uniform. It's about identity, freedom, and the courage to stand tall in the face of authority. Let's begin. It was a crisp spring morning in London, and tourists flooded the courtyard outside Buckingham Palace. Cameras clicked, children pointed, and families gathered to witness the changing of the guard, an iconic ceremony blending pageantry, discipline, and royal tradition. Among the Queen's guards, standing as still as statues in their red tunics and bearskin hats, was Sergeant Daniel Wright, a decorated soldier with over a decade of service. His face was unreadable, his posture flawless, his presence every bit the embodiment of military pride. But something, ever so small, caught the eye of a curious tourist standing near the railings. Nestled just beneath Wright's collar, occasionally visible when the wind shifted or when he turned slightly during ceremonial commands, was a thin silver chain bearing a small, unmistakable cross. It was modest, no larger than a thumbnail, but it glimmered against the uniform's black neckline. A whisper spread through the crowd, some in admiration, others in question. Was it allowed? Was it part of the uniform? Was this a new tradition? Unbeknownst to Wright, a formal complaint had already been submitted to the Royal Guard's Command Center by a visiting dignitary's assistant. According to them, displaying a religious symbol while on official military duty not only breached the uniform code, but also potentially undermined the neutrality expected of personnel representing the monarchy. The incident was documented with a discreet photo, forwarded with an official note demanding an inquiry into the matter. Within 48 hours, the issue had reached the upper ranks. Though minor in appearance, the implications of a visible religious symbol on a ceremonial uniform were enough to warrant internal discussion. The Royal Guard's Code of Conduct emphasized visual uniformity and symbolic neutrality. There were strict regulations on jewelry, religious or otherwise, to preserve the appearance of impartiality, especially when representing the crown in public. Sergeant Wright was summoned for questioning. The tone was formal but measured. He was informed that he had breached uniform regulations by wearing a religious symbol in public view while on ceremonial duty. The punishment, though not severe in military terms, came in the form of a formal fine, an official disciplinary mark on his otherwise spotless record. For Wright, it wasn't the money that stung, it was the principle. He had worn the cross quietly for years, tucking it under his collar where it was barely visible. It was never meant to draw attention. It wasn't a political statement or an act of defiance. It was a piece of his identity, a quiet homage to his faith and a tribute to his late mother, who had given it to him before he joined the service. He had always made sure it never interfered with his duties. He had passed multiple inspections with it. Not once had he been told it violated protocol. Until now, the fine wasn't issued with cruelty, but it was absolute. A document was signed, the offense was noted, and Wright was expected to pay and move on. The commanding officer even offered him private reassurance. It's just procedure, nothing personal. But Wright didn't see it that way. To him, it felt deeply personal. He didn't see a rule broken. He saw a belief punished. The origins of the complaint traced back to an international visitor accompanying a foreign ambassador. This visitor, sharply dressed and observant, had been watching the changing of the guard with a critical eye, possibly assessing the display for diplomatic reporting or simple personal scrutiny. They noticed Wright's cross as he marched past, the chain momentarily visible in the sunlight. Where most might have overlooked the detail or admired its subtlety, this particular observer took issue. That evening, back in their hotel, they compiled a formal email. Attached to the message was a photo taken during the ceremonies, zoomed in on Wright's upper chest, with the chain clearly visible. The message was brief but direct. During today's ceremony, one of the royal guards was seen displaying a religious symbol in contradiction with what we understand to be the British military's commitment to visual neutrality and uniform standards. Such breaches, while perhaps culturally tolerated, raise concerns about precedent and professionalism, especially during state visits. The complaint was addressed not to the General Public Relations Office, but to a higher, internal channel within the Ministry of Defense. It bypassed standard review and found itself in the hands of those responsible for maintaining the integrity of ceremonial protocols. Within days, internal memos circulated among the command chain of the Household Division. The image was analyzed, the protocols were revisited. Was there a written clause that specifically prohibited such a symbol? The answer, yes, though the language was somewhat vague. Regulation 3.7 of the Royal Ceremonial Uniform Code states, "No personal adornments or symbols, religious or secular, are to be visible on the standard uniform during public ceremonial display, except those explicitly authorized as part of formal attire or medals of service." The wording left room for discretion, but it also gave authority the grounds to act. The decision to fine Sergeant Wright was not made in haste. Internal discussions acknowledged the soldier's otherwise exemplary conduct. Some suggested simply issuing a warning. Others argued that setting a precedent was more important than showing leniency. In the end, the disciplinary board agreed that a fine would be sufficient to mark the infraction without escalating the matter to suspension or reassignment. Word of the complaint and subsequent fine spread quickly among the ranks. Reactions were mixed. Some guardsmen expressed sympathy, viewing Wright's situation as an overreach, an unnecessary flex of authority over something so deeply personal. Others, though supportive of Wright as a comrade, believed uniformity must be upheld at all costs, especially in a role so symbolic and visible. Outside the barracks, the situation remained largely unknown. The military had no intention of turning the matter into a public spectacle. They expected it to be a closed chapter, fine issued, lesson learned, reputation preserved. But they hadn't counted on what Wright would do next. The guard, who had stood silent for years, both in duty and principle, had no intention of staying silent this time. The fine issued to Sergeant Daniel Wright was expected to be the end of the matter. A closed disciplinary action filed away in the record books, with no further attention required. But something in the way Wright accepted the charge triggered a pause within the upper ranks. He hadn't protested on the spot, nor had he signed the document in a hurry. Instead, he asked a simple question: "May I request a formal hearing?" The room fell quiet. The commanding officer, caught off guard by the request, asked him to clarify. Wright repeated himself. "I would like to challenge the fine through a formal hearing. I believe this action contradicts rights granted under the law." That sentence, delivered calmly and without resentment, began to shift the nature of the entire case. Military hearings were not uncommon, but they were rarely initiated by the personnel themselves, especially not for minor infractions like a uniform breach. The standard protocol was clear. Disciplinary actions could be reviewed through a tribunal, but doing so meant the case would be formally logged, reviewed by a legal officer, and discussed in a military court setting. Few soldiers took that route for fear of dragging out a simple issue or appearing combative. Yet Wright moved ahead with clear intent. He submitted a formal appeal, citing his right to challenge the action under the Armed Forces Act. Within days, the wheels were in motion. The Royal Guard's administrative unit scheduled the hearing at the Wellington Barracks, a secured and confidential military facility adjacent to Buckingham Palace. A tribunal panel was selected, comprised of one senior judge, one retired officer acting as a legal observer, and a serving administrative officer who would represent the commanding unit's position. Leading the panel would be Judge Sir Malcolm Grey, a highly respected legal figure in military law, known for his traditionalist views but also for his impartiality in upholding the rule of law. The nature of the hearing remained internal. There was no press release, no leaked information. To the outside world, it was just another proceeding within the quiet bureaucracy of military order. But inside the barracks, it sparked conversation. Why had Wright challenged it? What did he plan to say? Could he even win? Unlike civilian trials, this military tribunal would not be filled with lengthy arguments or dramatic gestures. It would be clinical, structured, and efficient. Each side would be given limited time to present evidence, make statements, and respond to questions from the panel. The prosecution, in this case, would be a commanding officer representing the Queen's Guard's leadership, tasked with explaining the justification behind the fine. As the date approached, Wright spent his off-duty hours in the small library annex within the barracks, poring over legal texts and previous military cases. He refused outside legal counsel, choosing instead to represent himself. This raised eyebrows among the ranks. Some called it bold, others called it reckless, but Wright wasn't acting on impulse. He had been studying law quietly for years, fascinated by the intersection of justice, tradition, and personal freedom. It wasn't a rebellion, it was a reckoning. The morning of the hearing was overcast, casting a gray hue over the stone buildings of the barracks. Wright arrived in full uniform, his posture straight, his face calm. The cross around his neck was not visible, not because he was hiding it, but because he wanted the case to be about principle, not defiance. The courtroom was a small, unadorned space, with wood, paneled walls, and rows of chairs, filled only by essential personnel. There were no press, no observers beyond those directly involved. The tribunal began promptly. Judge Grey presided with his signature precision, greeting each party with measured politeness before calling the room to order. The prosecution was first to speak. The officer presented the complaint, the regulation cited, and the image submitted as evidence. He emphasized that the military's duty to uphold visual neutrality and protocol was not a statement against faith, but a necessity for maintaining cohesion, order, and public trust. The fine, he said, was proportionate and fair. Grey nodded, made notes, and turned to Wright. Sergeant Wright stood and took a few steps forward. There was no podium, no dramatic flair. He held a single file folder containing printouts, annotations, and a small book, the Human Rights Act of 1998. Speaking clearly, he began by acknowledging the importance of military structure and the privilege of serving in the Royal Guard. He wasn't challenging the institution, he said. He was challenging the interpretation of the rules within the context of the law. He turned to Article 9 of the Human Rights Act, which guarantees every individual the right to freedom of thought, conscience, and religion, including the right to manifest their religion in worship, teaching, practice, and observance. That freedom, he explained, could only be restricted if it was necessary to maintain public safety, health, morals, or the rights and freedoms of others. Wearing a small cross, he continued, tucked under my uniform and invisible to most, does not endanger cohesion or threaten neutrality. It does not impede my duties or distract the public. It simply exists, quietly, because my beliefs don't disappear when I put on a uniform. He then referenced past legal cases in both civilian and military courts, where courts had sided with individuals in protecting religious expression within professional boundaries. One such case involved a nurse who was initially disciplined for wearing a cross necklace, but the court later ruled that the hospital's actions were discriminatory. Another involved a police officer who wore a turban, and the court recognized the need for reasonable accommodation in public service roles. The room was still. Wright's voice never rose, but his tone carried strength. He next addressed the symbolic irony of the Royal Guard's traditions. We serve the crown, yes, but the crown itself is tied to faith. The coronation is conducted in a church with blessings and sacred vows. We march to hymns. The monarchy is defender of the faith. We're not devoid of belief. We're surrounded by it. To deny the expression of a quiet symbol like a cross, even when it causes no disruption, contradicts the very history we're asked to protect. He paused, allowing the words to settle. Judge Gray scribbled something in his notebook. Then Wright continued, presenting documentation from the British Army's diversity and inclusion policy, which encouraged respectful accommodation of religious expression as long as it did not interfere with performance or safety. He also noted that no superior had ever warned him about the cross, and no member of the public had ever complained, until this one incident, spurred by a photo taken at the right moment under specific lighting. Wright concluded with a question, not a plea. If my performance, discipline, and professionalism are intact, and if no harm is caused, what then are we punishing? Is it the presence of faith or the appearance of it? He sat down. The room remained hushed, the weight of his argument hanging in the air. Judge Gray closed the file and folded his hands, the expression on his face unreadable, but notably engaged. Sergeant Daniel Wright's defense rested heavily on a cornerstone of British law, the Human Rights Act of 1998. This piece of legislation enshrines the fundamental freedoms and rights of individuals living under the jurisdiction of the United Kingdom, reflecting the principles laid out by the European Convention on Human Rights. Among these rights, Article 9 stands out for its protection of freedom of thought, conscience, and religion. Wright had studied it in depth, understanding the powerful legal shield it could provide in a situation where personal belief and institutional rules clashed. Article 9 declares that everyone has the right to freedom of thought, conscience, and religion. This right includes the freedom to change religion or belief, and freedom, either alone or in community with others, in public or private, to manifest religion or belief in worship, teaching, practice, and observance. However, the article also acknowledges that the freedom to manifest one's religion or beliefs may be subject to limitations prescribed by law and necessary in a democratic society, in the interests of public safety, public order, health, or morals. or the protection of the rights and freedoms of others. Wright's legal argument was precise and meticulous. He was not claiming an unrestricted right to display any symbol at any time, nor was he disregarding the importance of military discipline or protocol. Instead, he emphasized that his cross, a small silver pendant, worn discreetly beneath his uniform, did not interfere with his official duties, did not cause disorder, nor did it affect public safety. It was a personal expression of faith, hidden from casual view but deeply significant to him. By invoking Article 9, Wright highlighted that such an expression should not be curtailed unless the military could demonstrate a clear, justified reason within the narrow confines allowed by law. He referenced numerous legal precedents to bolster his point. The Human Rights Act has been invoked in countless cases across the UK and Europe, challenging restrictions on religious expression in workplaces, schools, and public institutions. While the military does have a unique status, subject to stricter regulations than civilian life, courts have generally required that any restrictions imposed must be proportionate and justifiable. One landmark case Wright cited was Ueda v. British Airways, where the European Court of Human Rights ruled that British Airways had unlawfully discriminated against a flight attendant who was sent home for wearing a small cross necklace. The court found that the company had failed to adequately justify their restrictions on her religious expression, setting a precedent that personal religious symbols could be reasonably accommodated in professional settings. Wright argued that his situation was no different. The Royal Guard, while bound by tradition and discipline, must still respect individual rights when those rights do not harm the institution's function or image. He argued that there was no evidence that his cross had caused any disturbance or complaint from the public, until the complaint was manufactured by a single observer. This isolated incident could not justify a blanket ban on religious expression. Further, Wright pointed out that the military's own diversity policies increasingly encouraged inclusion and accommodation of religious practices, provided these did not interfere with operational effectiveness. He stressed that the cross did not hamper his ability to march, stand guard, or represent the crown. To fine him for it was to punish his conscience unjustly. He also carefully noted the balance between rights and responsibilities. Article 9 protects freedom of belief absolutely, but allows restrictions on manifestation only when necessary. Wright emphasized that his cross was a reasonable, private manifestation that neither violated rules explicitly nor posed a risk. He asked the tribunal to consider whether the military's rigid interpretation of uniform protocol truly met the threshold of necessity required by law. This legal foundation was the crux of his argument. By grounding his defense in Article 9, Wright transformed what seemed a simple uniform violation into a question of constitutional rights, personal dignity, and the evolving nature of public institutions in a modern democracy. Beyond the legal texts and precedents, Sergeant Wright's argument gained strength because it was rooted in practical reality. He explained that his faith and his duties as a Royal Guard were not in conflict. They complemented one another. The cross was not a distraction or a disruption, but a symbol of personal conviction that gave him strength, resilience, and purpose in the demanding role he held. Standing motionless for hours, weathering harsh winds, heat, or cold, while maintaining the impeccable bearing expected of the Queen's Guard was a challenge few could fully appreciate. It required mental discipline, focus, and an unshakable sense of duty. Wright explained that his faith was part of his internal armor, something that helped him bear the loneliness, the scrutiny, and the pressure inherent in his position. He recounted personal stories of how his belief had shaped his conduct, reminding him to treat visitors with patience, to remain calm in tense moments, and to uphold integrity even when no one was watching. He talked about how the cross was a silent reminder of his values: loyalty, honor, and service, not only to the crown, but to the principles he believed in. The argument that religious symbols interfere with duties often hinges on the idea that they might distract the soldier or the public, or cause divisions within the ranks. Wright confronted this head-on. He presented testimonies from fellow guards who knew him well and vouched that his cross had never affected his professionalism or the unit's cohesion. His commanding officers, though initially cautious, later acknowledged his exemplary discipline and conduct. He also addressed the concern about public perception. The military, especially units as visible as the Queen's Guard, is expected to project unity and neutrality. But Wright challenged whether neutrality required the erasure of all personal identity and faith from view. He noted that the British public was diverse, with many faiths and beliefs represented across the country and the armed forces. To exclude religious expression was to deny the reality of modern Britain and the individuality of its servicemen and women. Moreover, he highlighted the irony in the military's own traditions. The monarchy itself is intertwined with the Church of England. The monarch's role as defender of the faith is central to British constitutional identity. The changing of the guard ceremony often includes hymns and prayers, a blend of duty and worship. How then could a soldier's quiet symbol of faith be deemed incompatible with a role that, historically and ceremonially, embraces religion? Wright's reasoning extended into the practical as well. He demonstrated that the cross was hidden under the uniform, never visibly large or flashy. It did not affect the appearance of the regiment's polished image, nor did it breach safety standards. Unlike other religious garb that might require accommodation, such as turbans or hijabs, the cross was discreet, personal, and unobtrusive. He further argued that the fine and the threat of further disciplinary action created an atmosphere of fear and suppression among soldiers who might hold similar beliefs. If one man could be penalized for a small pendant, where was the line drawn? Would the military now require uniformity at the expense of personal conscience? Would soldiers be forced to hide core parts of their identity in order to serve? Wright also brought forward the perspective of morale. Faith, he explained, was a source of comfort and strength for many soldiers. Encouraging openness and respect for religious expression could strengthen loyalty and well-being, rather than undermine it. The military's role, he said, should be to balance order with humanity, discipline with respect, and tradition with progress. Throughout his presentation, Wright maintained respect for the institution he served. His tone was not confrontational, but reflective, seeking to build a bridge between personal rights and institutional demands. He asked the tribunal to consider the spirit of the law as much as the letter, weigh the actual impact of his cross against the supposed necessity of uniformity. In making his case, Wright presented a vision of the modern military, one where tradition endures not through rigid suppression, but through thoughtful accommodation, where the uniform represents not uniformity of belief, but unity of purpose, where individual dignity is preserved and respect for personal faith is seen as a strength, not a weakness. This practical, reasoned argument won quiet respect from many in the room. It was grounded in experience, empathy, and common sense, qualities often lost in rigid bureaucratic enforcement. By the time he finished, Sergeant Daniel Wright had done more than defend his right to wear a cross. He had challenged the institution to evolve, to recognize that true discipline includes respect for conscience, and that service to the crown can harmonize with the freedom to believe. He highlighted the deep religious roots embedded within the British monarchy and the military traditions that surrounded his service. The history of the Royal Guard was intertwined with faith from its earliest days. The coronation ceremony, for instance, was steeped in Christian symbolism, conducted in Westminster Abbey with prayers and blessings that linked the monarch's authority to divine sanction. Wright argued that this was not mere ceremony, but a reflection of how faith and duty had historically coexisted in the very fabric of British governance and public service. He pointed out that many symbols carried by the military, such as medals, regalia, and flags, often bore religious connotations. The Union Jack itself incorporated the Cross of St. George, and regimental standards frequently displayed Christian iconography. This legacy demonstrated that faith was not separate from, but a vital part of British identity and the military's ethos. Wright suggested that the insistence on suppressing personal religious symbols like his cross was a departure from this heritage. It was an attempt to enforce a strict secularism that failed to acknowledge the reality of the individuals serving within the ranks. By insisting on absolute uniformity, the military risked alienating soldiers whose faith was a core part of their identity and motivation. He further argued that acknowledging religious expression did not mean allowing overt proselytizing or disruption, but simply recognizing the right of individuals to maintain their beliefs quietly and respectfully. This recognition, he said, would enhance cohesion rather than undermine it, fostering a culture of respect and understanding within the forces. The tribunal listened intently as Wright made these points. The judge, Sir Malcolm Grey, asked questions seeking to understand how Wright's expression of faith meshed with his role, and whether any complaints had arisen from colleagues or the public. Wright replied honestly that no one within his unit had ever raised an issue, and that the only complaint had come from an external observer, triggered by a photograph rather than actual disruption. The judge appeared to consider the broader implications. If a soldier's quiet symbol of faith was penalized, what message did that send to others who might come from different religious backgrounds? Was the military truly prepared to enforce a policy that might exclude or marginalize faithful individuals? At the heart of Wright's argument was a challenge to the assumption that religious expression and military professionalism were mutually exclusive. He insisted they were complementary, not contradictory. The discipline demanded by military service required inner strength and conviction, qualities often nurtured by faith. Wright's articulate defense and respectful demeanor earned the respect of the panel, gradually shifting the tone from one of strict enforcement to one of thoughtful consideration. The legal basis, combined with historical and practical reasoning, created a compelling case for reconsidering the fine and the policy behind it. Judge Gray's questions moved beyond the specifics of the case, probing the military's willingness to adapt to a changing society. Wright's responses were measured, emphasizing the need for balance, holding tradition and discipline while respecting individual rights and diversity. The hearing concluded with the panel reserving judgment. Though no immediate decision was announced, the atmosphere in the room had shifted. Wright had not only defended his own position, but had sparked a broader conversation about faith, identity, and service in the modern military. Sergeant Daniel Wright's unexpected legal challenge sent ripples through the military establishment. prompting senior officials to reconsider not only his case, but the broader implications of religious expression within the ranks. As the tribunal's deliberations continued, the story quietly reached influential ears in the Ministry of Defense. The issue was no longer just about a single cross worn beneath a uniform. It was about the fundamental rights of service members and how the armed forces balanced discipline with diversity. Behind closed doors, military lawyers began analyzing the case in light of existing policies and international human rights obligations. They scrutinized the details Sergeant Wright had presented, the Human Rights Act, Article 9, and the precedents set by civilian courts. Many found themselves acknowledging the strength of his argument and the risk of legal challenges if the military maintained a rigid, uncompromising stance. At the same time, conversations emerged about the evolving face of the armed forces. Britain's military, like its society, was increasingly diverse, comprising personnel of varied ethnicities, faiths, and backgrounds. Leaders recognized that fostering an environment where individuals could express their identities respectfully was crucial for morale, retention, and operational effectiveness. The rigid uniformity demanded in the past was giving way to a more nuanced understanding of inclusion. Public opinion, though mostly unaware of the specifics, also leaned toward respecting individual freedoms, especially when balanced against institutional needs. The narrative of a loyal soldier standing up not to defy the crown, but to assert his rights resonated widely. Some commentators framed it as a test case for modernizing military culture while preserving its core values. Meanwhile, the tribunal's focus remained on the particulars of the case. Sergeant Wright's calm, articulate presentation contrasted with the procedural rigidity of the prosecution's stance. He was no troublemaker. He was a conscientious individual seeking fair treatment. The panel appreciated this distinction, recognizing that the matter transcended a simple disciplinary action. The judge, Sir Malcolm Grey, was known for his fairness and adherence to legal principles. His experience with military law and human rights made him well suited to weigh the competing interests carefully. The hearing had brought to light the tension between maintaining order and respecting personal freedoms, an issue faced by many modern institutions, but particularly sensitive in the military context. As the tribunal prepared to issue its verdict, it became clear that the decision would set an important precedent. It would clarify how religious expression was to be managed within one of the most tradition-bound institutions in the country. The outcome could influence policy changes, shape training programs on diversity, and guide future disciplinary procedures. Sergeant Wright's case exemplified how individual courage and knowledge could challenge established norms and provoke meaningful change. His insistence on defending his rights through proper channels, armed with legal understanding and respect for the institution, highlighted the evolving relationship between personal liberty and public duty. The military's response to this challenge would be closely watched, not only by service members but by the wider public and human rights advocates. It would demonstrate whether the armed forces could reconcile centuries-old traditions with the demands of a pluralistic society. Throughout the process, Wright remained composed, aware that his fight was bigger than himself. His actions invited reflection on what it meant to serve loyally without sacrificing one's identity and beliefs. He became an inadvertent symbol of progress, showing that the military could be both disciplined and diverse, both respectful of heritage and open to change. The tribunal's deliberations drew on comprehensive legal analysis, testimony, historical context, and ethical considerations. The fine originally imposed was scrutinized in light of whether it was proportionate, justified, and consistent with human rights standards. More broadly, the case prompted a review of regulations governing uniform policy and religious accommodation. Military officials began consulting with religious leaders, diversity experts, and legal advisors to develop guidelines that balanced operational needs with respect for individual beliefs. This approach reflected a growing recognition that the strength of the armed forces lay not only in uniformity and order, but in embracing the varied backgrounds and convictions of those who served. Such inclusivity was seen as enhancing unit cohesion by fostering mutual respect and understanding. The ripple effect of Wright's case extended beyond the barracks. It contributed to wider discussions about religious freedoms in public institutions, encouraging other organizations to reevaluate their policies. His quiet determination became a catalyst for change, inspiring service members to speak up for their rights and prompting leaders to listen. Sergeant Wright's journey illustrated the power of informed, principled advocacy within established systems. His willingness to face the military tribunal alone, armed only with legal knowledge and conviction, challenged assumptions and encouraged a more humane, modern approach to discipline and identity. The case underscored that the military's traditions were not fixed relics, but living customs capable of adapting to the times. It showed that protecting individual rights and maintaining collective discipline were not mutually exclusive but complementary goals. As the tribunal's decision neared, all eyes were on how this balance would be struck. The verdict would resonate far beyond the courtroom, shaping the future of religious expression and personal dignity within the armed forces. Sergeant Daniel Wright's story had become more than a disciplinary case. It was a defining moment for justice, faith, and service in modern Britain. Thanks for watching A One Story Teller, where every story teaches, inspires, and challenges. If you felt the power of Sergeant Wright's journey, hit like, subscribe, and share this story with those who value courage and justice. Remember, your voice matters. Sometimes it just takes one person to change everything. Until next time, keep believing, keep fighting, and keep listening.